Mr. Lana, my screen shows that you are unmuted, or that you are muted, pardon me. You need to unmute. Thank you, sir. Will you be presenting the argument this morning? Afternoon. I'm sorry, well, it will be shortly afternoon. I guess it's still technically this morning.
No, I have an opening, and then Ms. Silva will be presenting everything else. Reserving just first few minutes to talk.
Judge, 1 second, please.
So there's someone else going to be presenting then today?
Yeah.
Okay. Are they there with you?
No, they're going to be coming in. There we go.
Hello?
I
hear
hear a voice, but I don't see anyone.
It's Evelana Silver. Hi.
Hello.
We're dividing our time. Max has an opening with some of his concerns, and it's about 3 minutes. And then the balance of the 15 would be mine, and then 5 minutes reserved for rebuttal, which will be mine.
You have a total of 20 minutes, so you will be going 3, 12, and 5?
Yes, maybe 4 for Max, wherever he finishes.
Whatever he uses comes out from the 15, and then we can segue in to the next speaker right after that. And as I'm the timekeeper, I will let you know when you arrive at the 15-minute destination so that you can decide. I'm sorry.
Oh, forgive me. I was trying to work my video.
Okay. I'll give you a moment for that. Is your camera turned on by any chance?
Yes. Okay.
No, you're not. We still only see Max. Wait, there you are. You're with us now. Good. Fantastic. Okay. Then with that be resolved, we can proceed. Okay, Mr. Lana, you have the floor, sir, and you may begin.
All right. Hello, my name is Maximus M. Lana. I am a 22-year-old pro se appellant and currently suffering from a severe concussion. So I'm limited both in time and by physical ailment. I will also be reading so I do not lose my train of thought. Today I'm speaking for the first time in 11 years because I was 11 years old when the court case in this state began to adjudicate my rights to my grandmother's estate, even though her estate is under the exclusive jurisdiction of the courts of New York where she was domiciled. And so I would like to raise subject matter jurisdiction error because it is fundamental and needs to be reviewed by this court. I understand that a fundamental error in a subject matter jurisdiction can be raised at any time, and that it's the court's duty to notice them, even if the parties don't. The appellate courts of New York issued a landmark jurisdiction case in 2018, citing a legal and evidentiary basis for their exclusive in rem jurisdiction. If the courts of Florida want to have continuing jurisdiction over the property in this case, which is not located in Florida, then I believe the courts must announce the basis for this jurisdiction, because this has no personal jurisdiction over me otherwise. I am and always have been a domiciliary of New York. The jurisdictional error has been compounded by a 14th Amendment violation because I have never been appointed an independent representative by the courts of Florida. And the entitlements to the judgment in this case were decided when I was still a minor in January of 2017. I was substituted into this proceeding in October 2017, shortly after I began college, and only a few weeks before the October and November 2017 hearings for fee amount were then held. This was not fair to me, given how many documents need to be reviewed before a six-figure judgment is awarded, and even my counsel, whom I could only afford for the fee hearing, asked for a continuance and was denied by a judge who was later disqualified for prejudice. So I am now facing judgment that is a result of nested fundamental errors. And may I ask, why is this the case? I also understand that there may be a third fundamental error caused by allowing one co-defendant to act as counsel to another. Though defendants in a tort and civil conspiracy case may be entitled to have common defense, they are not entitled to help each other and then bill for attorney's fees, nor are they entitled to use an attorney-client privilege to subvert discovery. I am not aware of any precedent for this, and if the laws of the state permit these fundamental errors, they violate U.S. state constitutions and thus give rise to several federal claims, since I belong to 4 protected classes and I have been discriminated on the basis of all these jurisdictions. There is no explanation for why I have not seen a penny of my inheritance, and my distributive shares have been used to pay Mr. Filos for defending his co-defendants. This is why we have recently requested that case 21-2165 be resolved before a final judgment is approved in this case, because there is no point to reviewing an award of attorney's fees granted to someone who may not be entitled to those fees as a matter of law. This much I can understand because it is fundamental. And so I ask this court to review these issues before issuing a final order. Thank you for your time.
Thank you.
So has my clock begun?
It's still running.
Okay. I don't know how to do this with Zoom, but I'm going to need documents because there's 16,000 pages. So I'm going to just pause the video so that I can get back my screen and speak to you largely with record citations. I want to just dovetail one thing about what Max said here, because there was a recent, rather frantic attempt to get in a motion for consolidation, abatement, and stay with 21-2165, which is an order requesting disqualification of Mr. Filos as counsel, and that was denied by the lower court and is on is a non-final order on review. I will say this: the answer brief filed by Appellees opens the door to this, because on page 4 of it, apropos of nothing, it says, said counsel was never served with process or appeared as a party in this case. I refer you to record page 12,457, 12,297, where literally a caption is being amended. Mr. Filos is present. He gives his spelling for the amended caption. And then on February 13th, 2015, an order gets issued. So I don't know if I can screen share. I was told in training you cannot. I can't do demonstratives because I'm not there. So I'm actually have many documents open in order to reach the many points in this. But I do take, Max has been puzzled by this non-adversarial sort of approach to have co-defendants in a conspiracy to claim, be defendants for themselves, lawyers for each other, and then bill. No precedent that I could find. And the courts did not listen to my many objections to this and treated it, normalized it indeed. And indeed, Mr. Filos first ignored it and then raised this notion of service and process at the first day of the motion for summary judgment hearings. And those are in the record, the hearings for June 1st, 2017. Certainly at the end of discovery is not a time to let everyone know that you've decided not to don the yoke of defendant. I'm not sure why someone would feel that they are defendant proof. We've sued presidents and princes, and the law is the law. So more of that was said in my emergency hearing, and there are supplemental authorities that were submitted on this point exactly, because it is a fundamental error and it's not going away, nor is the subject matter jurisdiction. And that has been put before this court since 2018. I will judicially notice the court's own records. Certainly nothing can stop this court from looking at its own records when it decides this, and these are not things that one can move past. As far as the substantive issues here, as the brief says, there's a problem with the evidence. There is really no substantial evidence to support a six-figure, now with insurance, attorney's fee. And the evidence that is cited in the reply brief is in the answer brief is very scant. Due to the pandemic, I could barely get the briefs done. That's another unexpected disadvantage of being in the wrong jurisdiction, is we now have, New York courts shut down for a year. Meanwhile, Florida is asking me to do 3 appeals, and we're Wuhan, USA. So that shows how a sort of defect at the very bottom, at the base, can have these ripple effects beyond just being a fundamental error. So the reply brief did not get in there, and I apologize for that. And but I did spend a great deal of time taking a 14,000 page record and condensing into volume 1 of the appendix, which is before you. And you can see very clearly the flow of the proceedings. And this case was pretty much docketed to summary judgment and done within eight months. And in the 6th month, we discover that a defendant is not choosing to be a defendant. In any event, but rather counsel to the remaining defendants. So that's, I have no words on that. The dean of my tax law program also has no words for that. So I don't know where else to go. Now, as far as the methodology and his talking just about what's going on with the billables, assuming we have no fundamental errors and we just get to the nitty gritty of what's the problem here, you will find no substantial evidence for what's going on. And a total insufficiency of evidence is equal to denial of due process, and therefore also a 4th fundamental error, FB v. State 852 Southern 2nd 226. That's Florida Supreme Court on that, and that was in the supplemental authorities. I will point you to the record, which due to its length, and I don't have a visual, I'm just calling out record numbers. Give me a moment here. The discovery that was given to us was actually a draft affidavit, which wasn't even an affidavit. And so there's no original records that were, there's double hearsay records were submitted. This is very well detailed in the actual fee hearing, which was done by our counsel at the time, Dan Bushell. And in the transcript of the fee hearings, some real anomalies occur. For example, there was an affidavit brought to court that Mr. Filos brandished on the first day of hearing. There are 3 days of hearings, one in October 24th, the other is in November 13th, earlier in November, and then the final one is November 13th. The early November one had absolutely had the bulk of it and the experts and the testimony. So that's kind of the core of it. And in that, the actual experts were sequestered until Mr. Filos could finish testifying. And they were sequestered the first day entirely, which is unbelievable because they're experts. They're there to actually, contribute to the proceeding. And so during that proceeding, the first day, Mr. Filos brings, just a second, sorry, I'm gonna get my timeline, here we go, okay. There is all over the appendices, every appendix of the 3 appendices I submitted, the first one is literally top to bottom proceeding, complaint to final judgment, to even motion for rehearing, which takes us to January 2018. The final judgment was subsequent to the 3 hearings. The 3 hearings are October 24th, November 13th, all 2017, and November, 10 days later, November 13th. The first day we had to have a continuance because even the court had to admit we had 0 evidence. What was handed to me, because I was pro se until that point, and we had to reallocate funds and couldn't get a reply brief from this attorney because we ran out of funds. We had to move our appellate attorney over to this and ask him to come in. As I was a second-year law student, I had never done a fee hearing, and this obviously is technical. And then, Max, who you'll see was actually substituted into the proceeding on October 4th, 2017. So that puts us 3 weeks before the hearing. And by the way, Max also didn't receive a host of notices like the protective orders. I mean, it's just a due process travesty. But getting to the hearings, the first day of hearing was continued. And that's why we couldn't have a fee hearing until November 3rd. So 5 days later, Mr. Filos submitted what was double hearsay. And that's all in the record. And you can see it well organized in the appendices I created. And at that hearing, what happened was he had an affidavit, but he didn't want to submit it. And then the judge said, well, you can go submit it later, but he never did. Instead, he gave us these unsigned bills with draft all over it and then called them affidavits. And so got everybody to call them affidavits, even though they were unsigned, which is the sort of definition of an affidavit. And so basically we have double hearsay documents. We also have some inconsistencies as far as what these documents could mean. If you look in the appellate brief, in the summary, I put a picture right up front of what's called block billing. If you compare Mr. Felis's October 6th deposition, where he describes his billing practice, it's completely at odds with his actual testimony under oath. And the bills sort of show it. He claims always, he makes these notes to himself and on scraps of paper, and then puts them into some intermediate situation. And that's called block billing, which you can see it's just completely blacked out. What's odd about this is it serves no purpose other than to leave no data metadata in the document, because block billing, and I wish I could show it to you, it's on, it's actually in the summary I took of the initial brief, is probably the fastest way to find it. It's just a blackout, and literally the times were put and run into each other without even a return, a date, a space, serve no logical purpose other than to create something that either couldn't be read or didn't have a chronology. It could be created on a plain text file. So basically this eventually Mr. Fields then steps away from the idea that he has block billing and then says, no, I go right to the final bills. So there's three ideas here. One is I get a piece of paper and then I have an intermediate record, and then I make these records, and then I gut these records for the court convenience and just extract this work on this case, put affidavit all over it, and then hand it to you unsigned. And that clearly wasn't going to be competent evidence for $100,000 in fees. And then the second theory changed during the second day of the November 3rd hearing, when Mr. Fields was on the stand, and became, no, there is no intermediate record. I just go straight to the very records you see, making them contemporaneous records, when before they were like a hop away, because there was this block billing in between. And so I created a demo, a demo of this, the methodology, in Appendix 2 on page 560, which basically goes through this. And if you compare the October 6th deposition prior to the fee hearing, when all I had to work on, by the way, I had to go into depositions as a law student with just, these affidavits that were not really evidence. And throughout the deposition, he talked about intermediate records, but then suddenly they were gone. So
Forgive my interruption,
also,
but I need to keep my commitment to you. You have arrived at your 15-minute point, and you're beginning to invade the time that you have reserved for your rebuttal. The choice is yours whether to go forward or to stop. But at 20 minutes, that's all you get, as they say here.
well, I will say one thing. There's also the 1.525 violation for filing a motion for sanctions in September 2017, 8 months after the final judgment, after we'd adjudicated the entitlement and the fee amount. So all these are serious problems, I believe. I would like to reserve my rebuttal. Thank you.
Okay, thank you.
I'll return to the room. Sorry, I had to look at documents.
Mr. Felix, you may begin.
Thank you, Your Honor. If it please the court, I'm George Filos. I represent the appellee in this case, Plato J. Alexander. The appellants filed a non-conforming amended initial brief in this case, and likewise proceeded on an oral argument, which is contrary to the court rules by bringing up matters which were not mentioned in the briefs whatsoever. This court obviously has subject matter jurisdiction of this case because you all have subject matter jurisdiction of final judgments of the circuit court. And that is what is being appealed, the final judgment of the circuit court. Mr. Lange mentioned that the court never had personal jurisdiction over him. However, he's the plaintiff that brought the case. And when you file a case in court as a plaintiff, you are submitting yourself to the jurisdiction of the court. I mentioned that the amended initial brief filed by the appellants as non-conforming because they didn't follow the appellate rules of procedure nor follow the requirements of the court for presentation of issues for review. In the statement of the case and facts, there are only 3 citations to the record on appeal, 2 of which are incorrect. And obviously the statement of the case and statement of the facts is the foundation upon which you can make your argument in the argument section in your brief. Now, we've heard something about the 3,892 page appendix that the appellants filed, which condensed the 13,000 page record. However, that brief only contains 1 page with references to the appendix. There are 3 references to the appendix on that page, and 2 are inaccurate and 1 are misleading. So our point, as we made out in the brief, is that the bulk, if not all, of the arguments on appeal were waived by the appellants. This court is not obligated to rebrief a case for the appellant. You're not obligated to ferret through the record to find facts that might support an argument or come up with arguments for the appellants, but that's exactly what they ask you to do. On page 21 and page 22 of the initial brief, as the appellants are talking about the issue of entitlement to fees under the proposal for settlement rule and statute, they specify hearings and documents in the lower court, where they say, here are hearings and documents in the lower court that specify our grounds. And now I'm quoting from their brief. All aforementioned arguments made and authorities cited in the lower tribunal are incorporated by reference here and are sufficient as a matter of law to result in reversal of fee and cost entitlement based on offer of judgment. That, by the terms of the case law, is a waiver of the issue. Appellate's court will not consider issues unless they are properly raised and discussed in their briefs. As to the issue of section 57-105 entitlements, on page 27 of the initial brief, the appellants devote 1/2 a page to the 57-105 entitlement. There are no cited cases, and there's in essence no argument made, and neither the statement of the case or facts cite in the appellant's statement of the case of facts cite any reference to the record on appeal regarding that issue. That issue is waived. There was one statement made by appellant that the 57-105 motion for fees was not filed until after the final judgment. But as mentioned on our brief, the case law is very clear. It's the service of the motion rather than the filing of the motion, which keys in the timeliness, and it's undisputed that the 57-105 motion was filed before the final judgment in this case. Likewise, as to fee amount, the appellants claim that the judgment below was not supported by competent, substantial evidence. They devote 1 paragraph in their brief to that issue on page 32. And their argument is, the record, I'm quoting now, the record below demonstrates that the fee awarded by the circuit court was unsupported by competent, substantial evidence and therefore needs to be reversed. Neither in that argument, if you're even going to call it an argument, or in the statement of cases and statement of facts, do appellants cite any reference to the record on appeal regarding that issue. That's also a waiver of that issue. Aside from the issue of waiver, even if waiver didn't apply, the issue of entitlement under the proposal for settlement rule and statute has already been decided by this case in the first appeal, which is the plenary appeal from the summary judgment in favor of my clients, in which this court awarded my client appellate attorney's fees on the basis that there was a valid proposal for settlement under the proposal for settlement statute.
Mr. Philos, I think I'm going to have to disagree with you on that.
Mhm.
Because at the time that we awarded the attorney's fees, the issue of entitlement was not right. We did not have jurisdiction over it. So I think our award of fees pursuant to the proposal for settlement was made with the understanding that is contingent on the assumption that it was a valid proposal for settlement. That was not resolving as a matter of law that you were entitled to fees pursuant to the proposal for settlement, because that was not yet ripe for adjudication. So I think you're jumping the gun on that, because we didn't have jurisdiction to decide it. And if we had, that would have been invalid.
I would respectfully disagree for this reason, Your Honor, that the lower court had already ruled that we were entitled to fees under the proposal for settlement statute, but entitlement was decided by the appellate court, by the trial court, prior to the appellate court entering its award, I believe. It's only the fee judgment as to amount that was subsequent. But in this court, and the second point I wanted to make is that this court's award of appellate fees in the plenary appeal was not conditioned. And I've seen many orders of this court conditioned on subsequent findings of the trial court. But the trial court had already ruled that we were entitled to fees under the proposal for settlement statute.
That's true, but my point is, and that's absolutely true, but you're arguing law of the case. And what I'm saying is we have not yet decided, because we did not yet have jurisdiction to decide entitlement.
Well,
even though that had already been decided and it theoretically was encompassed in the notice of appeal, it was premature. We don't have jurisdiction to determine entitlement until the fee award is final. And that's when we can weigh in on entitlement and amount.
Your Honor, we've cited in the case, the Crouch case, which was this court's case from 2008, which I believe is identical in the facts. And to look at it even a little further, if this court, to accept Your Honor's proposal, if this court decided in this appeal that the proposal for settlement was invalid for some reason, so there's no entitlement as to proposal for settlement, then you would have two direct and contradictory opinions of this court, because the appellate court in the plenary appeal could not have awarded appellate fees unless the proposal for settlement were valid. And then you'd have a situation where you have a mandate from the first appeal requiring the trial court to award fees under the proposal for settlement, and then a decision of this court saying we're not entitled to. And that's exactly why you have law of the case, not to have contradictory opinions. So I would respectfully disagree, but moving on from that, Your Honor, even if the law of the case didn't apply, I wanted to talk a little bit about the merits of the, aside from waiver and law of the case. Regarding Max as a minor and conflict of interest, the initial complaint in this case sought to do away with Max's grandmother and Eva's mother's estate plan, which in fact effectively gave everything to her grandchildren. And the initial complaint asked that her estate plan be overturned and Eva and her sister would inherit her mother's estate and in essence disinherit the grandchildren. And we raised the issue. We said, that's a conflict of interest. Eva and Max have a conflict of interest in this case. And Ms. Silver filed a motion and said, Number one, there is no conflict of interest because we're going to dismiss our initial complaint and we're going to file an amended complaint, not seeking to overturn the estate plan, but for tortious interference of an expectancy, and our interests are aligned, which is exactly what happened. And in fact, Ms. Silver also stated that she's the court-appointed guardian of the property of Max. So there was no conflict of interest here requiring a guardian ad litem be appointed. In fact, it was the appellants themselves that opposed the appointment of a guardian ad litem. As to Max as a minor, I know of no case, no rule, no statute which says that when a guardian of the property of a minor files a claim in court, they're not subject to the same rules and statutes regarding attorney's fees as any other litigant. And I think it's also very important in this case to note that before the judgment was entered in this case here, Max filed a motion granted by the court where he said, I'm not a minor anymore. I want to join this litigation as an adult. That was his choice. That's the choice he made, and the law is clear. He stepped into the shoes of Eva as guardian of the property for Max, as to Max as an adult. And so there was nothing inappropriate. There was nothing unfair about this judgment being entered against Max. Just briefly on 57-105 entitlement, and may I ask when I have 3 minutes left, Your Honor, if that's...
Well, you're a little late for that because we're at 13. No, I'm sorry. You don't have any reserve time. You're at 13 and about half, so you have 6.5 minutes left according to my mathematical skills.
Thank
I
you.
caution you, I was a liberal arts major, not a math or science.
I trust your mathematical skills completely, Your Honor.
You can thank the nuns then, because that's who beat it into me, I guess you'd say. Made me learn.
On 57-105 entitlement, it's important to note how brazenly frivolous this lower court action was. And of course, frivolous, you don't have to prove frivolousness for 57-105 these days. The whole basis of this suit, which took years to litigate, was allegedly that Eva's mother, Max's grandmother, Paula, was ill. She was terminally ill. And that these are the allegations of the plaintiffs, that their mother and grandmother intended to gift all their assets to them while she was still alive. And she would have done so had Eva and Max been informed of her illness. But because they weren't informed of her illness, they didn't have the opportunity to encourage or facilitate those inter vivos transfers. And that was a tortious interference with their expectancy. Shockingly, prior to that complaint even being filed, the appellant filed in a probate matter, the related matter, statement saying, Eva asserts that her mother intentionally hid her illness from her family. Eva asserts her mother intentionally hid her, her assets, her finances, her illness from her family. The pith of their complaint was known by them to be false even before they filed it. If there's any case that you can think of which deserves a 57-105 entitlement to fees, it's this one. And even that, the judge also found and noted that in his summary judgment, but also found you can't have a tortious interference when there's no tort and there's no duty for one person to inform another of their medical condition. So this was a baseless, frivolous lawsuit, which begs for 57-105 entitlement. Regarding the competent substantial evidence for the fees, the raw billing records were introduced into evidence. The client billing was introduced into evidence. Now, it is true that the raw billing records do have things blocked out, but that's because, as was testified and explained, counsel was representing appellee on multiple matters. So the matters in other cases for which compensation were not sought in this case were blocked out, number one. In addition to the records, the counsel testified at length to the fee. Counsel's expert testified at length to the fee. The judge adopted the figure that was testified to by the appellee's expert witness. That constitutes competent substantial evidence. The law is clear. Billing records, attorney testimony, expert testimony, that's what comprises competent substantial evidence for a fee amount. There was a
We
mention.
have 2.5 minutes left.
Thank you, Your Honor. Regarding block billing, I'll point out the statement, and it's mentioned in our brief by appellant's own expert witness, stating that he didn't find the block billing objectionable. Of all the hours introduced in this case, there were about 25 hours or so that comprised compensable and non-compensable matters. And the law is very clear, as long as the attorney testifies and allocates them, that's sufficient basis to award fees on that basis, which the record shows. The testimony was that the attorney went back, looked at those, allocated them. If he wasn't sure of the time, he went back to the actual file if necessary. So there's competent substantial evidence. The lower court belabored over this fee hearing over 3 days, made multiple accommodations to the appellants who were represented by appellate counsel. So we respectfully ask the court to affirm the judgment of the lower court in this matter. Thank you. And we yield back the rest of our time.
Do I start?
Just a second. I want to make sure that I'm set to write down my notes on your presentation in the right spot.
No problem.
Thank you. You may proceed.
Okay, I'm running timer. Sorry, I'm going to talk really, really fast. With regards to Max, settlement never offered to him. Record 12,219 to 12,297. Responses to why the settlement with the entitlement should not be had given at the entitlement hearing. Max could not be offered settlement because you need an independent settlement. I was appointed as guardian of property in New York, not in Florida. Two, not just one, two fiduciaries were supposed to marshal the assets that are in the motion for summary judgment dismissal. The motion for summary judgment dismissal, even in case 165069, says that the personal representative was supposed to go for these assets. So we filed with my attorney this case, and we had to file it here because they had fraudulently initiated a probate here, and New York took 4 years to sort it out in the appellate level and the Court of Appeals. My case is held in every treatise from Surrogates Heaton to New York jurisprudence. I wrote the entry for Westlaw. Okay, so basically, when I also wrote this brief, I am sorry it's not conforming. It was November 2020. We were in a meltdown. We are not slackers here in New York. Our courts just opened right now, and I had docketed 3 appeals. I had to pick and choose. I have read your opinions, especially Judge Casanueva, big fan. And I just thought, well, they're smarter than me. What I did was what I could do. I took that 13-page positive record. I made one big long running record with a table of contents. I said, here are the facts. And then I took all the authorities I had, and I didn't bother putting them everywhere. I made them by theme. They're not alphabetical. They're thematic. I think you know what to do with the case law. I don't have to instruct this court. So I did what I could under the circumstances. There's also a very young pro se person who submitted the work. So for its defects, Mea culpa. I apologize. I put the law and the facts together. The law is nothing more. And that's what I learned in law school. As far as the sanctions, the sanction is the most painful of all, because even Judge St. Arnold, who actually had in 4205, you reversed a 14th, he sanctioned me without hearing or notice for raising domicile. On 3,000 pages, I got sanctioned in Florida. On 1,500, I made the books in New York. But Jack St. Arnold, he did issue in November 2011. He would have issued, and I submitted it last night with my motion to consolidate Appendix 1 that shows how the jurisdiction was stolen. If I don't have any jurisdiction in New York because I've been duped, I went to law school. They duped me twice. It wasn't going to happen. I went to law school for my son during the pendency of this between 2015 and 2017, got a degree in 2 years because we had attorneys dropping off, sanctions weaponized, and the wrong jurisdiction, and New York turned me away. I had to overturn 2 surrogates in New York to get the jurisdiction to repatriate my mother's will because all the property is in New York. So at the moment this was filed, which we were confronting a 4-year statute of limitation on undue influence, why would Judge St. Arnold actually appoint Gary Fernald to basically marshal, and he puts it in order, $220,000 worth of assets that the Alexanders somehow got within a year of when my father died. And I will say this about my family. I asked my mother to give everything to my son because I don't even collect child support, and his father's a senator. So this was then uncovered in a letter that's in the record for my mother. So saying that we have overreached, there is an apartment, please read the reply brief in 2D165069, where I explain what has been distorted so terribly in this last bit that we just suddenly woke up and decided we were going to pull a fast one. No, my mother disappeared for a year, and because they wanted the co-op, they didn't transfer the co-op. They just kept hoping, I guess, that she would live or they wouldn't tell New York. I have no idea. This is another situation probably to be taken up in another jurisdiction. New York has those records. Mr. Philos and the Alexanders participate in my mother's last case, which survived her, for that co-op, which incidentally was assigned to the Alexanders 90 days before she signed the will. Before that, it was Max's. We were living there and we lost it by operation of law because it's a Mitchell-Lama co-op and they didn't know that. So net, this, I would like to say, if you could just look at that first appendix, if you just see the record and put together the law and yesterday's filing, which speak to these fundamental errors that I cannot speak about them because I've carried the fate of my son, and kindly understand he was never offered a settlement because I couldn't accept a settlement. Plus they sneakily put the settlement, even though there's millions of dollars writing on this, under 14,000 so that it wouldn't actually trigger the Florida laws about guardianship where, you know, if a minor has to have a settlement above a certain threshold, you need somebody in there, you know, but to wit, there are 2 infants at this moment in the probate that have no guardian. How does this happen? This is an interstate, it's a federal case. It's got two states fighting for probate. So how do the Florida kids have nothing? My son, whole childhood gone, but there are 2 infants there. So I ask you, please, the facts and the law. I don't need to school this panel on that, and I did the best that I could. But what we heard now, that was very far. That was spin. And as Mr. Fields have it, he'd like to waive conflict, the Florida bar, subject matter jurisdiction, and the due process. Well, if we waive all that, what is our country? How can you waive it? It's unwaivable. So the fundamentals are just so bad. I implore you to look past my defects and realize what is at issue here. Thank you so much. I don't want to go over. Thank you.
Well, don't worry, I'll let you finish it up. You have gone over, but we're at a good stopping points, everything is well. I thank you all for your presentation today. The panel and I hope you all stay well in this interesting time in which we live. And that will, I guess, conclude this case. And I guess they bring you back over to the other location, wherever that is located. And that concludes the court docket today. I thank you all again.
Thank you, Ron.
Thank you.